And I failed to ask the interveners if they had anything to state. At this time, do Ms. Abraham or Ms. Hadamio have anything to state?
I would like Counselor Abraham to go first, please.
Okay. Ms. Abraham? Do you wish to address the court?
Yes. I guess I am just, I feel like we were railroaded into a meeting which Mr. Bassett attended the closed session on. He chaired the meeting as mayor. He made all of the deciding votes. He voted, he was the tiebreaker on every one of these issues. And it was not a fair meeting of the governing body. I feel like we went there and were totally disregarded, totally ignored, and they just did what they wanted to do to go about their merry way in getting Mr. Ayal to represent the town to fight against what the citizens have said, which is they just want us to enforce our ordinances. And that's all we're trying to do is make sure that we're not spending taxpayer money defending against doing what we should be doing anyway. And I do feel like Mr. Bassett was in the closed session. We couldn't have any real conversation. And we've been trying since we were served with this back in February to actually have a meeting and discuss how do we want to proceed. And we have not been able to because Mr. Bassett would not allow it. We had one meeting finally scheduled, which was canceled because of COVID. But we have not had any real meetings of the governing body to decide if we want to defend against a suit that says we just want you to obey the rules. So that's my concern.
Yes, Ms. Hadamio?
Thank you, Your Honor. I just wanted to reiterate the point that in my memory, you have stated on 3 different occasions that John Bassett is not the mayor. You've said it repeatedly. He continues to defy you. You've said it that he's not the mayor since October 14th, I believe. The meeting that we did have was not a legal meeting for a number of reasons. The first being that our operating resolution requires us to have, and I believe it's state statute as well, to have 3 members of the governing body call the meeting, and that did not occur. We did not agree to the time and place. Counselor Abraham and I were just told when it was. I had requested agenda items that they left off and they added others. And as you know, Your Honor, too, we have the Governmental Conduct Act. This former mayor's pattern of behavior has been to defy the law in every instance of what personally benefits him. Okay? So he, at our objections, continued to vote on things that benefit him and or his family personally. So how can he instruct the governing body what action to take and break all of the ties when he has a conflict of interest on those votes? It's fundamentally wrong. But yet he voted in attorneys for himself. They are now saying, I saw something filed that we are objecting to the writ of mandamus, and something was filed with the Supreme Court. But Mr. Ryle had told us that he was going to investigate Mr. Bassett and come back to counsel whom he purportedly represents the 4 of us remaining And then we would decide exactly what to do from there. So the way I see it is that, they're defining what your order is and the steps that have to be gone through. And I just want to follow the law. I want to do things legally. I've said that before, Your Honor. And what they did with that meeting was illegal in a number of different ways.
Thank you.
Thank you.
Okay. All right. The court has known that this is a very contentious issue that's been risen regarding the mayor and the council and interveners, all parties. And from the onset, the court noted that this was approached by the plaintiff and moving forward to get the judgments that this was following as he best thought and as the court thought was following the law, and still believes that the court was correct in that the court made its rulings. However, in looking at what occurred and what has been filed, looking at the intervener's order, which was proposed in the court, granted that there was a flurry of activity and that the writ of execution did provide a different date of removal than when was after the date of the meeting of the town and the members. The court sees that there is some confusion by the defendants as to the Chapter 44 method of removal of the mayor, and hopefully plaintiff has enlightened the parties as to their methods in pursuing removing this mayor. The court did quash the writ of execution. However, the motion in order to show cause was already filed. The court is going to find today that there was some confusion, and I'm going to give the defendants the benefit of the doubt based on the confusion of the writ of execution and what took place, whether this was a different way of removal of the mayor, what was the court's order, and this was all pending, that the court will today not find and deny the motion for order to show cause at this time, and will not grant the motion for order to show cause based on the reasons. And I am giving the defendants the doubt that this was their intent at that time because of the confusion in the process and possibly not being clear as to the Chapter 44 process and the court's writ of execution, which was later quashed, that they may not have intentionally defied the court's order. So with that being said, we can now move to defendant Rael's renewed motion to set aside default. Oh, excuse me, Mr. Chair, yes?
Can I just add one other thing or ask for a point of clarification? I understand that you are denying the motion for order to show cause, but will you also require the governing body to convene another meeting to address the questions that were still left unaddressed without the participation of the mayor given his removal at this time? That motion is not before the court.
Okay, excuse me, who's speaking? I can't, okay, you're garbled. Can you, everybody mute their line? I can't hear you, Mr. Kennedy.
That motion is not before the court.
So you're objecting that the motion is not before the court. Is that what you said, Mr. Kennedy?
Yes, the motion you just heard from Mr. Terry is not before the court.
All right, I was a little garbled. I want to make sure that is what you stated. All right. Okay. That is correct, Mr. Terry. For today's purposes, that the court will just ask that I'm denying the motion in order to show cause. Okay. Can you renew that in motion? Anything else, Mr. Terry?
Well, the only thing that I'm trying to find out, and again, this point of clarification, give me if I'm speaking in terms of farmers. I'm just trying to make sure that the vote that occurred at the special meeting on November 2nd is not being ratified by the court in operation of denying my motion. Because the mayor participated and the mayor has been removed according to the court orders. So I believe that another meeting needs to be convened.
Well, again, Your Honor's already denied that motion as not being before the court. That matter in particular is in front of the Supreme Court. I would suggest that Mr. Terry is out of line and that we should move on from from the denial of the order to show cause motion.
Okay. All right. And for today's purposes, Mr. Chair, if you want to bring a motion later addressing those issues, you may do so. But for today's purposes, the court is only ruling on the motion for the order to show cause, and I'm not ratifying anything beyond denying the motion for to show cause. And I would ask you, Mr. Kennedy, if you could draft the order and circulate that to all parties and back to the court by November 16th.
I will, Your Honor.
All right, thank you, Mr. Kennedy. All right, moving on to Defendant Riles' renewed motion to set aside default judgment.
Your Honor, thank you. May it please the court. As set forth in the briefing, Your Honor, the governing body of the town of Edgewood requests that the default judgment entered on October 14, 2020 be set aside pursuant to Rule 55 and Rule 60 of the New Mexico Rules of Civil Procedure because that judgment is void as a matter of law. And I'd like to add to that Your Honor's order of October 30th in which the intervener's order in which you Mr. Terry argued that you stated the mayor was removed, as well as Your Honor's order of November 5th, 2020, in which Your Honor states under number 3 that the defendant John Bassett was removed from the office of mayor for the town of Edgewood upon the entry of the court's order for default judgment against him on October 14, 2020. First, Your Honor, default judgment is void in this matter for lack of service. As plaintiff's first amended complaint upon the town of Edgewood as a named defendant in this matter, Your Honor, that's the difference here. Is that this is the first time that we were required to be served as a named defendant, the town of Edgewood, to be served as a named defendant in this matter. There has been no actual service of plaintiff's first amended complaint on any of the defendants in this matter, much less the town of Edgewood. While the docket evidences that the town received service of the plaintiff's original complaint, Your Honor, that fact is irrelevant to the question that's presented here today. Before the town's answer came due, the plaintiffs filed their first amended complaint as a matter of right. It's crucial to bear in mind, Your Honor, here that the plaintiff's first amended complaint asserted a key town action pursuant to the Fraud Against Taxpayers Act, and thus the first amended complaint was filed under seal. Well, the first amended complaint was under seal. State Statute 44-9-5, subsection B states, no service shall be made on the defendant and no response is required from a defendant until the seal has been lifted and the complaint served pursuant to the rules of civil procedure. That's very clear in the statute, Your Honor. Mr. Terry chose to amend his complaint. He chose to add a key town action, and therefore Mr. Terry has to follow what the state statute states. The plain language of the statute illustrates the fact that until the seal was lifted, the town of Edgewood, as a named defendant, again, Your Honor, as a named defendant, could not have been served, and no response could have been due. Additionally, under Rule 15 of the Rules of Civil Procedure, Rule 15 provides that the deadline to file a responsive pleading is calculated upon service of an amended complaint. Based on the statute and applicable rule in this case, Your Honor, the earliest date on which the town of Edgewood could have been served with the plaintiff's first amended complaint was September 16, 2020. And Your Honor, that's the day that Your Honor entered the order lifting the seal in this matter. That's the earliest date that the town could have been served. Now, Mr. Terry and the prior hearings have made much ado about the fact that the town had received and had notice of the lawsuit, had reviewed the lawsuit, and it had done so in its capacity to determine whether or not it wanted to become a key town plaintiff. Again, the service could not be made upon a defendant until such time as the seal was lifted. In fact, Your Honor, the town did not even receive service of this court's order to lift the seal, which again you entered on September 16, 2020, and the town was not identified in that order, Your Honor, was not identified in that order as a party entitled to notice of the same. It follows, therefore, that today, Your Honor, no response on behalf of the governing body of the town of Edgewood has come due. Further, Your Honor, the default judgment in this case cannot be saved by Mr. Terry's argument that the town of Edgewood was constructively served with the first amendment complaint. As required by the Fraud Against Taxpayers Act, plaintiffs provided a copy of the first amendment complaint to the state of New Mexico as well as the governing body of the town of Edgewood for the purpose of advising the respective governmental entities of their right to intervene as plaintiffs in the Contempt action, not to serve them as named defendants in the action. That's the key here. The purpose for providing the governing body of the town of Edgewood is not only statutorily required, but the plaintiffs themselves describe this as the purpose for providing the first amendment complaint. And you'll see that in the attachment to my motion, Your Honor. It's a letter from Mr. Terry dated February 24, 2020, in which he states that the purpose of providing it was for us to determine whether or not we wanted to become a Contempt plaintiff in the matter, not as service of defendants in the matter. In other words, while it's true, Your Honor, that the governing body of the town of Edgewood received a copy of the first amendment complaint, it did not receive service as required by the rules of procedure in its capacity, again, as a named defendant in this matter. Nonetheless, Your Honor, even if you, for argument's sake, decide that the town received constructive service of the first amendment complaint, constructive service is an insufficient basis upon which default judgment may be entered. And that's from State of New Mexico versus 1984 Pontiac 6000, 1990, New Mexico Court of Appeals at 085 at paragraph 9. Your Honor, the procedural history that the town of Edgewood as a named defendant in this matter has not been served with the first amendment complaint, and thus, with entry of default violates the town's right to any due process. As a result, default judgment is void, and pursuant to Rule 60B4, it must be set aside. There's no discretion, Your Honor. In Clausen v. Clausen, which is 1995, New Mexico Court of Appeals 022 at paragraph 13, the court states, when the grant or denial of a motion turns on the validity of the judgment, as in a Rule 60B4 motion, which is what we have here before you here today, Your Honor, discretion has no place. Secondly, Your Honor, the default judgment is void for lack of notice required by Rule 55B prior to entry of the default judgment. As the court is aware, Your Honor, Rule 55B requires that the party against whom a default judgment is sought is entitled to written notice at least 3 days prior to the entry of the default judgment. The procedural facts, which are uncontested here, Your Honor, establish that the town of Edgewood, again as a named defendant, had affirmatively signaled to opposing counsel and to the court that it intended to submit to this court's jurisdiction and defend against the claims at issue as early as September 3rd, 2020. This fact was confirmed by a telephone call following the special meeting which the town had on September 3rd, 2020, in which the town of Edgewood declined the invitation to intervene as a Contempt plaintiff in this matter. More importantly, however, Your Honor, an entry of appearance was filed by my firm on October 12, 2020, providing notice of appearance by representation on behalf of the town of Edgewood as a named defendant in this matter. Additionally, a second entry of appearance with the Contempt action caption added. The only difference, Your Honor, was that the original entry of appearance on October 12th didn't have the Contempt caption. The entry of appearance that was filed on October 14th had the Contempt caption added. That entry of appearance was filed on October 14th at 12:10 p.m. Again, providing notice of representation on behalf of the town of Edgewood in this matter. Nonetheless, without prior notice, the court entered its order of default judgment against the town of Edgewood on October 14th at 1:41 p.m., which is an hour and a half later than even our amended entry of appearance was filed, Your Honor. It's worth highlighting here, Your Honor, that the New Mexico Court of Appeals relied on a case in which the entry of appearance was filed only minutes before the entry of a default judgment, and it held that if a party has appeared in an action, default judgment can only follow upon 3 days written notice. And that's from Gandara versus Gandara, 2003, New Mexico Court of Appeals 036 at paragraph 22. There can be no dispute, Your Honor, that the town, as a named defendant in this matter, had signified to counsel for the plaintiffs and to the court of its intent to submit to the jurisdiction of the court prior to the entry of the default judgment in this case, yet it did not receive notice as required by Rule 55, subsection B. This failure to provide the required notice again deprived the town of its right to due process, and as a result, the default judgment must be set aside because it's therefore void as a matter of law. Finally, Your Honor, the default judgment is a legally insufficient writ of mandamus against the town and must be set aside. As plaintiffs have repeatedly asserted in this matter, the only cause of action alleged against the town is count 3 of their amended complaint, by which plaintiffs seek a writ of mandamus to the town of Edgewood to file a complaint or otherwise institute legal proceedings to remove its mayor for alleged malfeasance in office. Because this is the only claim against the town, the default judgment in effect is a de facto writ of mandamus. In fact, in their public commentary regarding these proceedings, the plaintiffs have repeatedly described the default judgment as a writ of mandamus. And Your Honor, I would encourage you to look up a website called Eye on Edgewood, in which Mr. Terry and the plaintiffs appear numerous times commenting on the case, and which they described the judge's order, the court's default judgment order as a writ of mandamus. However, Your Honor, the de facto writ of mandamus is legally insufficient. It's well established in this jurisdiction as well as across the country that the purpose of a writ of mandamus is to compel the performance of an act which is statutorily prescribed. The New Mexico Supreme Court has long maintained that mandamus cannot issue to direct a public entity to perform a particular act from multiple alternatives. And that's El Dorado at Santa Fe Incorporated versus Board of County Commissioners of Santa Fe, 1976, New Mexico Supreme Court, 029 at paragraph 5, Your Honor. In this case, the plaintiffs rely on section 3-10-7 to seek mandamus. However, the plain language of that statute indicates that there are at least 2 alternatives for the town of Edgewood when presented with a judicial finding of malfeasance by an elected official. The governing body for the town may or it may not seek removal by complaint in district court. But that's the key there, Your Honor. The governing body of the town, the writ requires the governing body of the town to determine whether or not it wants to seek removal and file a complaint in court. That is the correct procedure to remove any elected official of a municipal governing body from office. Accordingly, Your Honor, a writ of mandamus to compel the town to seek removal of Mayor Bassett by complaint in district court is contrary to the well-established legal authority and purpose of the remedy. Further, Your Honor, the rules of civil procedure outline the procedure that is necessary to request a writ of mandamus from a district court. Rule 65C requires that, quote, application for a writ shall be by verified petition filed with the district court, accompanied by the proposed form of the writ with a copy of the petition appended as an exhibit, end quote. The plaintiff's first amendment complaint, Your Honor, is not a verified petition, nor was it accompanied by any proposed form of writ. Next, Your Honor, a writ issued by a district court, quote, shall direct the respondent or respondents to serve and file a responsive pleading within a time specified in the writ, and if a date of hearing is set, the date, time, and place when the hearing will be held. And again, Your Honor, that's Rule 165C. The order of default does not direct the town to file a responsive pleading within a specified time. Further, Your Honor, the rule goes on to state further, quote, no peremptory writ shall be issued unless a date not later than 10 days after its issuance is set for a hearing at which it may be challenged. The order for default does not set a hearing at which the writ may be challenged or at which the order for default may be challenge, Your Honor. Though the town's amended motion to set aside was set for hearing on October 27th, 2020, the court didn't allow me to present our challenge to the order for default. Finally, Your Honor, as a de facto writ of mandamus, the order for default judgment is legally insufficient as it fails to set forth factual allegations or findings that the town of Edgewood has a ministerial duty to act as directed therein. Accordingly, Your Honor, the default judgment entered against the town should be set aside as a legally deficient de facto writ of mandamus. In sum, the order of default judgment against the governing body for the town should be set aside for insufficient service, Your Honor, because we were never served again, and the key here, Your Honor, is as a named defendant. It should be set aside because it's void for lack of notice pursuant to Rule 55B, and it should be set aside as a legally insufficient writ of mandamus. Your Honor, thank you for allowing me an opportunity to present these arguments finally here today before you on behalf of the town of Edgewood, and I stand for any questions that Your Honor may have at this time.
Thank you, Mr. Al. Response, Mr. Terry?
Thank you, Your Honor. Here's what's important. Mr. Rial raised some arguments to the court today. Some of those arguments are procedural. Other of those arguments are substantive. As to the substantive arguments, I think it's important to note that the rule for default judgment says that while you may have had substantive arguments, you didn't appear and defend and present those arguments to the court. Therefore, they're waived. So let's go back now to the procedural issue. The plaintiffs filed a lawsuit. They served the lawsuit against the town back in February. Subsequently, the plaintiffs amended their lawsuit. This was on March 2nd. We originally, and this was a technical snafu with the electronic filing system, we originally tried to file that amended complaint on February 24th. And it was rejected through the e-filing system because it was a big document and we sent it in portions and the clerk said we want it submitted differently. So we did. And it didn't ultimately get filed until March 2nd. But under the Contempt statute, it says that the day you filed the complaint, so when I initially did it, this is February 24th, you need to send a copy to the AG's office and to the town because they're the political subdivision who I am alleging has been defrauded of monies under the Fraud Against Taxpayers Act. So I sent this letter, and Mr. Ryle referenced it. It's February 24th, and it's addressed to the governing body for the town of Edgewood. There's no dispute that they got that letter. Then, as we move forward in time, because I sent a copy of the amended complaint on February 24th with its e-filing receipt, that subsequently when I actually got the amended complaint filed, I took an endorsed copy and I served it on Mr. Ryle by email on March 8th. So they got it in multiple formats at multiple times over a span of about 2.5 weeks. They had notice of the action. The rules of civil procedure provide that you're supposed to serve copies of pleadings on all parties who've appeared. This is Rule 5. And Rule 5A says that you don't have to file, or you don't have to give service of pleadings to parties who are in default. So, under the rules, I filed certain documents, nobody had appeared, but nobody was entitled to service. One of the things that Mr. Rial has brought up in his argument, and I think it's very, very important to address, is he's trying to say that the town of Edgewood is a defendant in the key TAM portion of the case, and therefore is entitled to the operation of the statute which says that no defendant in the key TAM portion has to file a response until the seal is lifted. Well, here's where the error lies. you'll notice that this case has a very big caption. And it's because it actually has two captions. Caption number one was the initial complaint, where the town was listed as a defendant. This is not the Contempt portion. And subsequently, when the complaint was amended, you got that second additional caption up at the bottom. But if you look at that second additional caption, what you're going to notice is that the town is not a Contempt defendant. The town is the Contempt plaintiff. And my clients are the relator parties who have brought the Contempt lawsuit in the name of the town. So I don't think there's any reasonable construction of the fraud against taxpayers statute where you can say that the town is a Contempt defendant when they are in fact the Contempt plaintiff. That's why they got the February 24th letter. That's why they got the notice that they had an opportunity to intervene in the action, because they were the plaintiff, not the defendant. So I think any argument about the town related to default judgment for the Contempt portion of the case failed as a matter of law because they were the plaintiff and not the defendant. So now that we've established that the town has received a service of process, they've also received a copy of the First Amendment complaint, the Fraud Against Taxpayers Act provides a procedure by which the town is supposed to decide whether they're going to prosecute the case or not within 60 days. Well, that 60 days came and went in May, and the town just let that deadline roll, and they refused to take any action. And I contend because it was in the benefit of the mayor, and he pretty much controls how the town does their operations. Nevertheless, as we fast forward in time, I did begin having communications with Mr. Rial in late July or August, okay? And then they were intermittent, and then we had a meeting that came in September. So Mr. Rial is the town attorney, and he's made that representation multiple times before the court. And he had notice of the lawsuit. He had a copy of the First Amendment complaint. He chose, for whatever reason, not to enter his appearance in the action. And then ultimately the town held a meeting on September 3rd. Following the meeting, I sent Mr. Rial a proposed order saying that the town had held its meeting, they chose not to intervene, and that after 10 days, anybody who's been served with process in the action, that would be Mr. Bassett and the town, would be required to file a response in accordance with Rule 15A. Well, I sent this proposed order to Mr. Rial. I put his name on there for him to approve it, and he took no action. Maybe it sat in his inbox, maybe he was ignoring me. I don't know, but as the plaintiff's attorney, I'm trying to diligently prosecute this action to final judgment. So I looked at the court's local rules, and the court has two local rules that are applicable. One is Local Rule 1-114 about the submission of orders, and the other is Local Rule 1-201 about the submission of orders on motions. But the two rules are parallel to one another, and they provide a similar provision. I send the proposed order to opposing counsel. If opposing counsel does not respond to the proposed order within 5 days, then I am allowed to submit that order to the judge for entry. So I sent Mr. Rial this proposed order on September 8th. It's attached as Exhibit 4 to my motion for default judgment, and he didn't respond. And after the 5-day period under the district court's local rules, I submitted that proposed order to the court, and the court entered the order on September 16th. So I think despite the assertions that the town attorney had made his appearance known to me and that he was going to appear and defend in the action, he never did. And consequently, he wasn't entitled to notice. But from what I've represented to the court today and based on the exhibit to my motion for default, he had a copy of the order that the court entered on September 16th. He had it in his inbox on September 8th. So he had notice of it. What he chose to do with that notice is, that's beyond my control. So what we have here now is the reason for Rule 55 in the first place is that there are some people choose interminable delay as a litigation strategy for whatever reason, and that is clearly what the town did here, because you've heard from the interveners in previous hearings about how they were requesting updates on the lawsuit, and they got none because the mayor refused to give them. So we have intentional conduct, intentional delay, and intentional refusal to appear and defend. And now what the town is asking for is that Your Honor set aside the last 7 or 8 months, some 15, 20 filings with the court by the plaintiffs, including various certificates as to the state of the record to show people's non-appearance. I believe there's 3 of them, Your Honor. Including before filing the motion for default judgment on October 5th. And now the town is saying, you know what, we should just wash that away. These issues are important. We think we should do something with them now, and consequently start this case over from scratch and treat us as if we have clean hands, where clearly they don't. So I think the timeline is clear. The notice issue is clear. The town is not a defendant in relation to the Contempt statute. And I think as a final point, what is also important to note is that the allegation against the town in the initial complaint is unchanged from the allegation against the town in the amended complaint. The rules, so this is Rule 5A again, says, no service must be made on a party in default except for new claims which need to be served with process in the manner provided by Rule 4. But Count 3 in the amended complaint is not a new claim against the town. It's an existing claim. So I contend that the town's response obligations are governed by Rule 15A, which provides that upon receipt of an amended pleading, well, I shouldn't say receipt, it says when there's an amended pleading, a party shall respond within the original timeline set forth in the summons, or within 10 days if that time period is longer. The seal in this case was lifted on September 16th. The town did not file a response to the amended complaint within 10 days, as required by Rule 15A. In fact, they did not file their entry of appearance until almost a month later, and then filed a motion to set aside the default judgment sometime after that. I believe it was the following week. So, Your Honor, in this case, this is why we have Rule 55, to provide sanctions against people who intentionally use delay as a litigation strategy, and to prevent plaintiffs such as my clients from sitting in the wind forever. We followed the rules of procedure. The town was not entitled to notice of anything until they appeared, and they had a copy of the lawsuit with process and a copy of the First Amendment complaint all the way back in February. Thank you, Your Honor. I stand for questions.
I do have a question for you. You've described that the defendant town is not a defendant in the Contempt complaint, and if you could lay out a little bit better for the court to understand how the notice was satisfied, in which particular instance are you referring that they were not subject to the requirements? Is this for the service after the Fraud Against Taxpayer Act was claimed in the amended, or if you could lay that out a little more clearly as to when the notice of service doesn't apply, since they were not a Contempt defendant in the complaint, in the amended complaint.
Yes, I would say it this way, Your Honor. In the ordinary course, we had the complaint filed and then an amended pleading. And under the rules for amended pleadings, which is Rule 15A, the town was required to file a response within 10 days of the amended pleading. We had an intervening seal that was placed on the case by operation of the Fraud Against Taxpayers Act. And what that says is no service will be made on the Contempt defendants until the seal is lifted. But because because the town is not a defendant under the Contempt statute, because they are the plaintiff, the real party in interest, and their claims have been advanced by relator parties, my clients, the town cannot be a defendant in that action and is therefore not subject to the obviation of the need to file a response, because they're not a defendant under that statute. So that the statute is very clear. A defendant on the Contempt deal doesn't have to file a response until the seal is lifted. They're not a defendant to the Contempt claims. That's clear from the caption, and I also believe it's clear from the pleadings, but maybe there's dispute on that, I don't know. Nevertheless, the seal was lifted. Then that 10-day time period under Rule 15 was no longer told and began to run. The order was served on the town attorney pursuant to the court's local rules. The town attorney did not file a response as required by the local rules. I was therefore entitled to submit my proposed order to the court, which I did. I did not serve notice of that order on Mr. Rial because he had not appeared in the action and was not entitled to notice. But again, adhering to the rules of civil procedure, a response was required. None was filed within the appropriate timeline. A motion for default judgment upon a clerk's certificate of the state of the record showing non-appearance was filed of record with this court, and the court entered that order as it should have.
Thank you for that clarification, Mr. Terry. Mr. Rao?
Your Honor, I have a lot of rebuttal here. The biggest thing that I'd like to bring to the court's attention that I have a major problem with is Mr. Terry's lack of candor to this court. Mr. Terry is leaving out numerous phone conversations that he and I had, but I'll get to those in a second, Your Honor. Mr. Terry talked a lot a second ago about the local rule that requires him to submit an order to me for approval, and then if I don't respond to him within 5 days, then he's allowed to submit that order to the court for approval. Now, Your Honor, what he's not allowed to do is take my name off of the order as counsel of record so that I don't receive a copy of it, and I have no idea that Your Honor is entering that order. Mr. Terry wants everybody to follow the rules of procedure except himself, and that's ridiculous, and that's been the gravamen of the problem in this case from the very beginning. Now, that's one problem, Your Honor. What he's also leaving out, Your Honor, is that he and I talked the day he sent me that order. He and I had a phone conversation. During that phone conversation, I told him I had to discuss it with my client, that I would get back to him, but that I also needed some time to do so because of the COVID issues, and also, Your Honor, because I was trying to find additional counsel for Mayor Bassett. Now, Mr. Terry leaves all of that out of the record, because Mr. Terry doesn't want Your Honor to know that, because that then would require Mr. Terry to explain to Your Honor why he took my name off of that order. He was not allowed to do that. Even if for argument's sake, Mr. Terry's going to say that phone conversation never took place, he wasn't allowed to take my name off the order under your local rule. He was allowed to submit it and copy me on that so that I knew what's happening, and he didn't do that. Now, another problem, Your Honor, is it's undisputed, Your Honor, that neither Mayor Bassett or the town, nor any of the defendants in this matter, ever received the motions for default or the motion for summary judgment in this matter. None of the defendants received any of the motions. How are we supposed to know they were happening, and therefore how can default be entered against us without any notice, which I've already argued, Your Honor. We didn't receive the motions for default until an email from Mr. Terry on October 15, 2020, after Your Honor had already entered the orders in this matter. That's when I received the motions for default that Mr. Terry filed. Another issue that I'd like to raise, Your Honor, in rebuttal is Mr. Terry makes he's just making a big mess out of this, but Mr. Terry chose to amend his complaint and to add a Contempt action. Now, a Contempt action, as you know very well, Your Honor, seals the case. If the town would have, let's just say for argument's sake, the town decided, the order sealing this action from the court doesn't apply to us, we're just going to go ahead and move forward with this case, and we're going to file an answer, we're going to file a response, we would have been in violation of the court's order sealing the case. Now, that's the first part of it. Secondly, the plain reading of the caption, Your Honor, says, State of New Mexico, Thomas McGill, Jerry Powers, and Howard Calkins versus, and I'm going to just skip down, governing body for the town of Edgewood, defendants. Now, that is the key town caption, Your Honor. That's the key town caption. It names us as defendants. Now, it also goes on to say governing body of the town of Edgewood versus John Bassett, Josephine Bassett, and Eugene Bassett. That would have been, should we have elected to proceed as the key town plaintiff in this case, Your Honor, which we elected not to do. Now, one more time, Your Honor, Mr. Terry skips over the Fraud Against Taxpayers Act statute that states that a party, that none of the defendants in the action, it doesn't say just the key town defendant, it seals the case completely for everybody. And it says none of the defendants shall be served until after the seal is lifted. And that's in New Mexico State Statute 44-9-5, subsection B. It doesn't differentiate like Mr. Terry's trying to do. Mr. Terry is desperate, Your Honor, desperate to hold on to this default judgment action because he doesn't want to litigate this case fairly on its merits. He can't have this case both ways. He chose to proceed with the key town action. He chose to amend his complaint. He needs to follow the rules and follow the statute. I'd also like to point out, Your Honor, Mr. Terry, one more lack of candor that Mr. Terry's had to this court is that, yes, Mr. Terry served it upon the state of New Mexico as well as the town of Edgewood, after which he and I had numerous conversations, one of which was in July was let's get the New Mexico Attorney General's office on the phone and find out, first of all, he and I agreed, and I hope he doesn't dispute this, he and I agreed that the town of Edgewood wouldn't decide whether or not it wanted to intervene as a key town plaintiff until after we knew whether or not the state of New Mexico was going to choose to intervene. I hope he doesn't dispute that fact. When we had not heard anything from the state of New Mexico, we had a phone conversation and we said, let's get on the phone with the Attorney General's office and determine whether or not they are going to proceed as the key town plaintiff in this matter. They informed us that they were still making their decision. We then later received a notice from them, I think, 2 weeks, a month later, from them stating that they were electing not to proceed as the key town plaintiff in that matter, at which time I called Mr. Terry again, and I said, okay, now the state has decided not to proceed as the key town plaintiff in this matter. It's now the governing body needs to take this up and determine whether or not they want to proceed as the key town plaintiff in this matter. During the meeting on September 3rd, we elected not to proceed as the key town plaintiff in the matter. That left us as a defendant in the matter, Your Honor. And that then led to the motion, the motion to lift the seal, which this court entered its order on September 16th, again, which Mr. Terry was not allowed to take my name off of, whether or not he admits that we had a phone call or whether or not he just thinks I was ignoring him, as he stated earlier. Either way, the rules do not allow him to simply remove my name and not give the town or any of the defendants, for that matter, notice. The rules require him to submit the order with my name still attached so that I understand what's happening in front of the court. I therefore didn't receive Your Honor's order of September 16, 2020, which required all of the defendants, and Your Honor, your order of September 16, 2020 states as follows, requires any defendant that has been served. And again, we, the town of Edgewood, had not been served as a named defendant in this matter. Requires any defendant that has been served to file a responsive pleading within 10 days. Again, I didn't receive that order because Mr. Terry unilaterally removed my name from the proposed order and from the proposed motion, Your Honor, which he was not allowed to do. Again, Your Honor, the key town statute says that no defendant can be served. We have been in violation of the court's order sealing the complaint. Whether or not the defendant is one of the key town plaintiffs in the cause is irrelevant. It seals the case completely, seals the entire case. And Your Honor, that's all that I have at this point in time. I hope Your Honor will understand that this case needs to move forward on its merits, that removing any elected official by a default judgment, as your order of November 5th states, and as your order of October 14th states, and as your order of October 27th or October 30th states, that removing that is not the proper way to do that. Your Honor, if you allow this case to move forward, our writ of superintending control, I think, goes away. We can move forward with this case, and we can have the case heard on its merits. Mr. Terry and the plaintiffs are terrified of that. They're fighting every way possible to prevent that from happening because they don't want the case heard on its merits. Your Honor, the statute is clear as to how this case needs to proceed. It's clear that the default judgment order needs to be set aside, Your Honor, and I beg of the court to allow this case to move forward on the merits. Thank you, Your Honor. I stand for any questions you may have at this time.
As Mr. Al stated that it was on September 3rd that the town that decided not to be a contempt plaintiff. Is that correct?
Yes, Your Honor.
Okay, and what was done with that decision by the town? How was that conveyed in any way? Any party?
That same day, Your Honor, September 3rd, immediately following the meeting, I called Mr. Terry, informed him of the town's decision. That led to Mr. Terry then submitting to me the draft order to lift the seal, which he then removed my name off of. But I called Mr. Terry the same day, September 3rd, 2020.
And the proposed order is where you keep stating that your name was not on the proposed order, or was it following this proposed order? Can you be clear for the court?
Your Honor, when Mr. Terry sent me the proposed order and on email, and I'd be glad to provide this to Your Honor as evidence, and I think I did attach it to my motion, Your Honor. It originally contained my name as a party entitled to notice. However, when Mr. Terry unilaterally decided to remove my name, submit the order to Your Honor, which is what's causing all this trouble, is that Mr. Terry is not following the rules, and that's led Your Honor to enter some orders because there's been misrepresentation. He then removed my name, and the final draft of the order that went before Your Honor didn't have my name on it. Therefore, when Your Honor's order came in, I did not receive any notice of it, nor did any of the other defendants.
Okay. But for the record and for clarity, your name was on the proposed order that was submitted to you. Is that correct, Mr. Al? What was submitted to you, the proposed order had your name on it?
On the proposed order that was submitted to me, but not that was submitted to the court, Your Honor.
Okay, that's my question. So, and you did receive that, and you stated to the court that you needed additional time to answer, and that the 10 days did lapse before you responded. Is that correct, Mr. Al?
No, Your Honor. Upon receipt of that order, I believe the next day I called Mr. Terry, informed him that I needed time to talk to my client about it, as well as time to find additional counsel. A deadline was not set by Mr. Terry, stating you have to get back to me within 2 or 3 days. He never said any of that. He just simply then took my name off of the order and submitted it to the court without my name on it.
I guess, Mr. Ryle, I'm trying to clarify that there was no other motion, anything filed beyond to request more additional time than what's required by the rule for 10 days to oppose or to any proposed order according to local rules 1-14 and 1-201. That you filed no response to Mr. Terry. Is that correct?
Your Honor, I wasn't required to do so because that was never, those rules were never triggered because I never received the order that was submitted to the court. I received a draft proposed order, had a gentleman's agreement, which I have done many times with I've been practicing law in New Mexico for 20 years. I've never had a lawyer make an agreement with me and go back on that agreement until now, Your Honor. But that provision was never triggered because I never received the order that was submitted to the court. So I was never aware that the order was submitted to the court, Your Honor, so that time could be triggered for me to then contest that order. That never happened. All that happened was the order was submitted without my name on it, without any notice to me. Mr. Terry has stated repeatedly he didn't have to give me notice. So that provision motion was never triggered, so I was never given the opportunity to challenge the order lifting the seal, Your Honor.
All right. Thank you, Mr. Isle.
Thank you, Your Honor.
Okay. The court, having reviewed all of the pleadings and heard all and here today, is going to deny the amended motion or the renewed motion to set aside the default judgment. And my reasons are for this, Mr. Al, that there are a couple of reasons. One is that the town of Edgewood was not named as a defendant in the key time complaint. And more persuasively is that you were presented with a proposed order, and the local rule provides that when the proposed order is given to a party, it is then when that trigger of 10 days is in place, and that if there is no response, the court may enter the order. It is not after the court enters the order that the time is triggered. So there was, you stated before the court that you did receive service of that proposed order. You did respond within 10 days, and according to local rules 114 and 1201, the court could enter that order and because the 10 days lapsed and there was no response. So it is those local rules. When the proposed order is given is when those 10 days are triggered, Mr. Al. So for those reasons, the court is going to deny the renewed motion to set aside the default judgment on behalf of the town of Edgewood. And I would ask Mr. Cherry if you would draft that order circulated to council and submit back to the court by the 16th. Okay.
Your Honor, one small point, and it may not seem like much to you, Your Honor, but it is to me. Mr. Cherry is referring to me as former attorney for the town of Edgewood and all of his orders. I would appreciate it, Your Honor, if I was entitled to the respect and notification that I am the attorney for the town of Edgewood, and if he would also take judicial notice, I'd ask him I would ask yourself, Your Honor, to tell Mr. Cherry, as well as the interveners in this case, that they are required to submit orders to me for approval, and that they do not simply have to tell you in an email, Your Honor. We never submitted it to Mr. Rael for approval because you, Your Honor, said he's no longer the attorney for the town of Edgewood. So if you'll ask them to please at least follow that rule, I would appreciate it.
Okay. Mr. Rael, as stated earlier by your counsel, that is not before the court at this time to make a ruling and has now been presented to the court. So I'm not going to address that issue at this time. If you want to bring that up before the court at a later time to allow the other party to respond, we can do that. But as your counsel properly stated, that's not before the court at this time, and the court is not going to entertain that.
For them just to follow the rule, Your Honor, to provide opposing counsel with the draft of the order, that's just the rule. That's one of the rules of civil procedure. It's not a motion. I'm just asking you to instruct them to follow the rules of civil procedure.
Mr. Rael, that's again not before the court. You can. The court's not going to make any determination as it was presented before the court today, and the court's made its ruling, and it's all going to address. And as I mentioned earlier, when Mr. Cherry brought up issues he wanted to address, and was aptly stated, it's not before the court at this time. Okay.
Thank you, Your Honor.
Anything else from the parties?
No, Your Honor.
There being nothing further, this matter is adjourned. You may hang up.
Thank you.
Have a good evening.